Hello, and welcome to the video on Was Justice Antonin Scalia Hercules? A re-examination of Ronald Dworkin's relationship to originalism. This is an article that I wrote, and hopefully a lot of it will seem familiar to you from the readings that we've done in class and from the lectures, because the article is drawn from the readings we've done in class and lectures and kind of encapsulates my thoughts on the material. So it should be good review for you. And I also want to reiterate again that you by no means are required to agree with me in my interpretations and my category of principal originalism. You're certainly welcome and encouraged to form your own opinions. Part of me hopes that you'll find what I've said convincing, but if you don't, that's fine too. Okay, so, and what I'm going to do here is I'm just going to sort of go through and narrate the article, starting with Dworkin and legal positivism. And the article starts with a discussion of legal positivism as a search for objectivity. And we discussed this in the first half of our first part of the semester. Looking at Hart's critique of Austin's command theory. So Austin was an early legal positivist who had a command theory of law as law coming from a sovereign, and Hart critiques that by saying it's too narrow and it maybe covers criminal law but doesn't cover law in general. And for Hart, instead, Hart wants to adopt an internal perspective on the law, saying you have to look at how law is perceived by people who obey the law, not just by those who give commands. And one of the keys here is Hart's rule of recognition, which holds that the validity of laws come through public acceptance of the process of creation of the law. And this is, if you remember, sort of a procedural stance on Hart's part. It's not dealing with the substance of the law. Those are the primary rules. The rule of recognition is the key secondary rule. But Hart does still try to maintain objectivity in his understanding of the law, even though he has this internal perspective. Now, Dworkin doesn't accept that Hart can truly remain objective. Dworkin critiques Hart by saying that Hart's attempt to incorporate social acceptance causes Hart to step out of the box of an objective understanding of the law, and that he's necessarily incorporating moral considerations into his understanding of the law, and that, for Dworkin at least, deviates from the goal of positivism as it's embracing objectivity, a neutral understanding of the law. And as I've discussed in the article a little bit, I think Hart and Dworkin have a little bit of cross purposes here. Dworkin is aiming to understand sort of how judges should decide cases, whereas Hart's really looking more for an abstract definition concept of law, which is different than Dworkin's goal. But another key element of Dworkin's critique of Hart is that Hart cannot account for hard cases. So Dworkin's emphasis on judicial decision-making. And again, the idea here is that a hard case is one where there's no clear legal precedent, that judges are trying to decide for the first time. And Dworkin critiques Hart as relying upon rules which are rigid and don't allow for flexibility, whereas Dworkin instead has an emphasis on principles. And principles are a little bit more abstract, and they can be adapted and applied to any new situation. And they have flexibility, and they're sort of, I don't want to say guidelines, that sort of is a little bit too loose, but they allow judges to incorporate larger context into their decision-making, which gets to Dworkin's main point that law is not static. Its law is always developing, and that judges are constantly making new decisions. So let's then look at Dworkin's interpretivism, which is his theory of interpretation. So Dworkin, again, I maintain, at least tries to maintain positivism's goal of an objective understanding of the law, while at the same time adapting to law as a dynamic entity. So, Dworkin likes the positivist project of objectivity. He likes that aspect of Hart, but again, he thinks that Hart can't account for law being dynamic. I mean, Hart does have his rule of change, where you can change the law, but Dworkin's view of law as being dynamic is a little bit different than that. Dworkin's view is that the law, law exists through judicial decision-making, and that's not something that can be accounted for in Hart, and so Dworkin has to come up with a theory of interpretation that allows for that. And as I've suggested, I think Dworkin's interested in the question of what is the law. Again, this is the sort of how judges make decisions, trying to interpret the law, as opposed to Hart's more abstract question of what is law. But Dworkin's view is also that his version of interpretivism is more reflective of what judges actually do when deciding cases. As I've suggested, this is not really Hart's focus, but I think it's viable for Dworkin to have this as his focus on what he is attempting to accomplish, and again, within this context of maintaining objectivity in the law. And Dworkin seeks to do this through his chain novel approach, law as narration. A chain novel, we discussed it in class, is where you have a series of authors, and each interpreter is a new author. They have an existing story that they're trying to extend. And you can think of this in relation to judges deciding new cases based on past precedent. Judges aren't starting an area of law afresh. They are bound to what has come before them. And so Dworkin comes up here with two interpretive criteria for interpretivism, for judicial decision-making. The first is the dimension of fit. I've discussed this as being backward-looking. Fit means that you have pre-existing law, and that any new interpretation must be consistent with that existing set of law. The other dimension is the dimension of making the work, either the story or the case, the best it can be. And this is forward-looking because you're trying to say, well, how should the case be decided so that we'll have sort of the best result into the future? And, this is something that judges need to take into account. And it's really this second dimension that's going to be, to a large extent, the most complicated for Dworkin, because he has to come up with a way of making the law the best it can be without incorporating moral criteria into his decision, because moral criteria are external to the law. And Dworkin attempts to do this through his concept of Hercules. So who is Hercules? Hercules is, you think of it as a judicial supercomputer who has full knowledge of all judicial opinions, all other commentary on the law, interpretations of the law, basically everything up to that point that exists about the law, the whole development of the law up to that point, and subject matter expertise, but really just everything in the law up to that point. Now, Dworkin acknowledges that this is an ideal. It's not obtainable in real life. No real life judge can have that breadth of knowledge, but Dworkin describes Hercules as what a judge would do if the judge could spend an entire life on one case. And really this is sort of his description of Hercules as a methodology. Dworkin acknowledges that different judges are going to come to different rulings, different conclusions, and that's consistent with his theory, because again, he's really focusing here on a methodology, not on sort of moral direction of how any particular case should be decided. At least in the parts of his reading that I'm focusing on, he does have several other essays where he does reach sort of moral conclusions about how the law should be decided, but that's not what I focus on in my article. He comes up with this concept of law as integrity, meaning that judges, Hercules, should maintain a consistent interpretation of the law. And you do this by using the dimensions of fit and making the law the best it can be, that we discussed in the previous slide. And that if you have those as your goal and your interpretive methodology, then law will be internally consistent and also morally realized within the context of the law itself. And he applies this, and I, in the article, discussed the application of this to the McLaughlin case, which is, if you remember, it's the case about trying to decide if someone can sue for emotional distress who does not actually witness an accident, and Dworkin goes through 6 different possible answers and evaluates them in relation to the dimensions of fit and making the law the best it can be, and you can look at the article for how that plays out. Hercules, importantly for Dworkin, also stays within the box of the positivist objective understanding of the law. There's no appeal, Hercules doesn't make any appeal to external sources or to external skepticism. And external skepticism would be like a moral critique of saying that this law is wrong because God says it's wrong, or because some other moral criteria that's not internal to the law itself. You think here in natural law, so Dworkin is certainly not a natural law theorist, even though there have been people that have claimed he's a natural law theorist. They do that because he tries to come up with the internal morality of the law. But I think what those characterizations misunderstand is that natural law, by its very nature, relies upon external sources of validity, and Dworkin is trying to derive an internal source of validity of the law. And Dworkin also comes up with his one right answer thesis, which is that there can be only one right answer. And this is also something I think is misunderstood. Dworkin here is not saying that all judges have to decide cases the same. This is a methodological approach to remain internal to the law. And what he's saying basically is that you have to presume that there can be only one right answer when you're deciding a case, because that's the only way to remain internal. If you say, well, there are, even if you say 2 possible right answers to how to rule in this case based on the law, then effectively what you're saying is, in order to resolve that dilemma of which of those 2 interpretations should apply, you have to come up with something external to the law to decide between them, and that's what Dworkin wants to avoid. So you have to methodologically assume that there can be only one interpretation in order to maintain an internal approach to the law. So that basically is Dworkin and Dworkin's theory of interpretivism. Let's now turn to Scalia, the other sort of main actor in my article, so to speak, and look at Scalia's views on originalism. And in the article, I sort of start this section by having, by looking at providing an overview of different theories of jurisprudence, looking at strict constructionism, intent originalism. So strict constructionism basically is just looking at the text and trying to interpret solely on the basis of the text. Intent originalism is what was the intent of the drafters. Meaning originalism is the larger linguistic context of interpretation. Principle originalism, which is ultimately what I'm going to associate with Dworkin, is the idea that law embodies principles, and the founders perhaps intended to create abstract principles that could then be adapted to new situations. And there's also living constitutionalism, which I characterize as wanting to apply the law, the Constitution, to present-day circumstances based on moral, well, not necessarily moral considerations, but societal perceptions of the law, current understandings, but not necessarily tied to the past in the way that I characterize principle originalism as doing. And Scalia is, by his own terms, a meaning originalist. He rejects intent originalism because he says it's too rigid. You can't get from what someone thought in 1787 to now and try to figure out how to apply that to cell phones or what have you. And it's also unrealistic because there's no sole author to any law, and you may have debates, but you can't, from that, just sort of tell definitively what is the intent of the drafters. Meaning originalism for Scalia still adheres to a fixed content of law because it still allows for your sources of interpretation are the linguistic understandings at the time the law was drafted, and that's still fixed. But Scalia also sees this as having the benefit of being able to adapt to technological and other advances, because you can, from understanding the linguistic context, tell what a word or term or phrase might have meant, and that creates its own sort of its meaning can then be extended to different situations without having to necessarily rely upon something as sort of rigid as intent. So Scalia tries to interpret laws within the linguistic context at the time that they were adopted. So let's talk some then about the Scalia-Dworkin debate. And we'll start with Dworkin's take on Scalia. So Dworkin differentiates between expectation and semantic originalism, and just sort of briefly, expectation originalism is intent originalism, and semantic is meaning originalism. And I think Dworkin has a little bit of an over simplistic view of these, but these are the terms that he comes up with, and he accuses Scalia, incorrectly I believe, of being an expectation originalism, because I think what Dworkin's doing is he sort of is looking at, well, a couple things maybe. So he looks at Scalia as being conservative politically as a judge, and thinks that must mean that he's stuck in the past and using intent originalism. But I also think that Dworkin sees semantic originalism as being consistent with his view on interpretivism, and he doesn't want to say that Scalia is also a semantic or meaning originalist, because he fundamentally disagrees with Scalia and Scalia's opinions on the law. Now, what's Scalia's response to Dworkin? Scalia agrees with Dworkin. He says, he agrees that he claims to be a semantic originalist, and he says, I'm glad that we agree on semantic originalism. Again, Scalia explicitly rejects intent originalism because he uses the larger linguistic semantic context to interpret the law. And Scalia even, I discussed a couple of examples in the article, uses semantic meaning to apply amendments to new technology. So I talk about new technology or new social norms, so to speak. So, I mean, he discusses the Eighth Amendment, and Dworkin also discusses the Eighth Amendment. And Scalia's understanding of cruel and unusual punishment is has to be derived from the understanding of the phrase back at the time of the founding. But he also is able, with the Fourth Amendment, to come up with the right to privacy in the home. That doesn't necessarily exist, or it's consistent with the understanding of search and seizure back at the time of the founding, but it can then be extended to sense-enhancing technology, like a infrared camera that might be able to see inside of a house, so to speak, that Scalia is able to say, no, that's not acceptable because of the understanding of search and seizure and the importance of privacy in the home back at the time of the founding. So, with that in mind, with Scalia's response to Dworkin, it's worth asking, is Dworkin really a semantic originalist? And if so, is Scalia Hercules? And so to answer these questions, I look at Dworkin's originalism, which again I ultimately conclude is principal originalism. And I'll say principal originalism is, and I discuss this in a footnote to the article. I don't expect you really to look at the footnotes, but principal originalism is my term. It's not something that there are a couple of examples where this phrase is used that I could find, but they're not used in with the same meaning that I have it as. But and I discussed a little bit in class how maybe this is sort of sometimes called new originalism, sometimes called framework originalism, but my interpretation and application to Dworkin is different than anything that I've found elsewhere. I mean, there is an article called Dworkin's Originalism. All of this is kind of addressed in the footnotes, so if you're really interested in it, then you can read the footnotes. But I just want to make clear, this is sort of my own interpretation. I think it's defensible, but it's not something necessarily you'll encounter elsewhere. So, okay, but to get started, Dworkin agrees with the importance of semantic understanding in interpreting law, because it's not just for Dworkin that you have cases. You also have larger contextual meaning of those cases, and so he does accept and incorporate into his interpretivism social understandings of the law. But through his chain novel approach and interpretivism, he allows for those semantic understandings to evolve over time. And Dworkin views the framers as setting out abstract principles that should be applied as abstract principles, not as unbending, unchanging directives. So, for example, he talks about how the Eighth Amendment, cruel and unusual punishment, is purposely vague. The founders, you could imagine the founders wanted to say that cruel and unusual punishment is limited to what it means at that time. They could have said that in what they wanted, or they could have clarified it in other ways. The Constitution is an intentionally vague document, and then you have statutes that fill in the details and regulations that fill in the details from there. And so ultimately then the question becomes, I signaled this earlier, whether reliance on abstract principles, which Dworkin wants to do, risks deviating from the objectivity of the positivist project by incorporating sources such as contemporary interpretations external to the law. And this is essentially Scalia's critique of Dworkin and Scalia's critique of living constitutionalism that you see in some of the writings that were assigned. And I addressed this this central question through analyzing whether Scalia was Hercules. And I do this in sort of four main categories. The first being fit, Dworkin's interpretive criteria of fit. And you can see here sort of a different temporal dimension of interpretation between Scalia and Dworkin. So for Scalia, the source material is fixed at the time of adoption, whereas Dworkin, as I've been saying, allows for evolving semantic understanding to be his source of interpretation. And Hercules looks at the entirety of legal history to determine core principles of law, and any new interpretation has to be consistent with those core principles. And this is how he gets also this idea of principles into his theory of interpretation. And then there's making the law the best it can be, and this is, as I suggested earlier, a forward-looking attempt for Dworkin at least to keep the law from becoming morally stagnant. And you can think to the transformation from Plessy versus Ferguson to Brown versus Board of Education, and how that is really a result of evolving understandings of equality. And I had you read those two cases. I didn't have you read the intervening cases, but there were a lot of cases in between Plessy and Brown that were a gradual transformation of the understanding of equality in relation to education. And it's clear that at the time of Plessy was adopted because I think Plessy was an 8-1 decision, so I think it accurately reflects understandings at the time of education and separate but equal as being socially acceptable, whereas by the time of Brown, at least in the Supreme Court size, it was not. And I think you can only explain, and it was Brown versus Board of Education was a unanimous decision in the other way. And I think you have to view this as a reflection of changing understandings of the concept of equality and equal protection in the 14th Amendment that are just fundamentally different from what existed at the time the 14th Amendment was adopted, or a couple of decades later when Plessy versus Ferguson was decided. And so this idea of making the law the best it can be recognizes that societal beliefs, in fact, change, and that within the context of the law, people can try to improve the law. But at the same time, Dworkin, he can't claim that he's morally correct and Scalia is not without adopting an external critique. That was one of my points earlier. And so he has to come up with a different way of sort of reaching a different conclusion than Scalia that's not this fixed version of interpretation as being at the time of adoption of the law. And this is where his idea of law as integrity comes into play. So, again, Scalia wants the source of interpretation to be fixed and claims, at least implicitly, I mean, he doesn't really directly respond to, he sort of directly responds to Dworkin on this, but Scalia is more talking about living constitutionalism as a whole, which he probably would associate Dworkin with advocating. But Scalia says that, look, if you aren't fixed in understandings at the time that the laws are adopted, then this evolutionary approach that Dworkin uses is unavoidably going to incorporate moral considerations. And the way I understand Dworkin is that the key here is that morality has to be internal, not external to the law. And this is his idea of law as integrity. And again, this is based on his dimensions of fit and making the law the best it can be. So you have to draw upon the so the corpus of the law as a whole, and judges here are not making moral choices about how to answer questions or how to decide cases, but they're simply expanding the sources of law to include subsequent interpretations, applications, past the time that the law was initially adopted. And that this approach, this evolutionary approach, maintains the objectivity of the positivist project because all of these interpretations are internal to the box that is the law. And you get, if you think of the supercomputer, what are the inputs? The inputs are this box of the law, all of the prior cases, all of the societal interpretations. And really, it's the same type of inputs that would exist for Scalia. It's just that the temporal time span is larger. So, Scalia, if you're looking at something back when the Constitution was adopted in 1787, well, what do? You look at sources. And yes, the constitutional debates are important, but also broader social understandings at the time. I guess there weren't really cases because this is the beginning of the Constitution. But, and Dworkin would accept that those are valid inputs, but he'd also say, well, maybe there were understandings 20 years later, 50 years later, 100 years later about the Constitution that also need to be taken into account in this chain novel approach that judges today are trying to be consistent with. And because he's relying upon this evolutionary approach to law, he's not using living constitutionalism. He's not sort of abandoning the history of the law only to look, and instead only looking at how law is interpreted today, or what the meaning of law would be to society today. Rather, he's saying you have to take this evolution of the law and maintain an approach that's consistent with it. And just to give an example, a hypothetical example I talk about in the article, I say, look, so Eighth Amendment, cruel and unusual punishment. Let's just imagine that the existing Eighth Amendment is repealed and a new amendment with the exact same language is passed and adopted. And, if that were the case, Scalia, were he still alive, could he find what the meaning is today? That's what he would have to do. He's not looking back to 1787. He's looking to what the larger social context and meaning is today. But I would hazard, yes, he could. He might not be too happy about it, but it's something that he could because, again, the inputs are all the same. It's just the time frame that you're dealing with. And so, sort of bring this all together, we get to Dworkin's one right answer thesis, which is, again, still an aspirational methodology that necessarily situates judges in the present, but ultimately I conclude that Dworkin is a principal originalist because that's what's necessary to maintain the objectivity of the positivist project. Going back to the beginning of the article, talking about Hart and, Austin and Hart, and then Dworkin's critique of Hart, Dworkin wants to maintain that objectivity while at the same time embracing the benefits of principal originalism and operating at a bit of an abstract level. And so I want to read my conclusion to my article because I think it's a good summary of sort of everything that I've put into the article. They say, in the end, Scalia is not a perfect example of Dworkin's Hercules, though he comes close in some ways, certainly closer than Dworkin is willing to admit, and perhaps closer than any other U.S. Supreme Court justice. So I'm saying there is this bit of an overlap that maybe is not always acknowledged. This closeness, Scalia and Dworkin's shared fundamental similarities, transforms our view of Dworkin and his theory of interpretivism into an objective method of judicial decision-making grounded in a successive series of stories that build upon one another, but which do so in a way that adheres to the internal logic of the law. This is Dworkin's attempt to remain inside the box of the law. Dworkin describes law as integrity as the idea of law worked pure. It's a quote. Law worked pure. For Dworkin, purity in the law comes from seeking and assuming a coherence of the law as presently constituted, a purity resting upon law viewed as a whole, again, the whole corpus of the law, without any need to introduce sources external to the law in deciding hard cases. This purity and the Hercules who embodies it remain a noble goal for judges and all interpreters of law to emulate. So again, it's an aspirational methodology. So that's my understanding of Dworkin, and the reason why I conclude that he is a principal originalist. Again, my term. But if nothing else, if you don't agree with my take on it, which again is fine, I think my article and this lecture serve as a good summary of most of what we've, or at least a lot of what we've discussed so far this semester. Thank you.